That's Mark Stevens. We're going to do a bonus section here for the No State Project here on for episode 50, which should be up shortly. But glad to be with you guys here. And what we do here on the No State Project Skype chat, especially if you're new, is that if you're defending against a charge from a bureaucrat, a bunch of us have been through this before and know how to do the role playing and to anticipate what judges are going to say, what prosecutors are going to say, and so that we can help people who are new learning how to defend themselves to be able to effectively answer them and make the right objections. So that's what we're doing today. So if you're interested in this, Skype me at FrankRizzo3 and we can get you into the Skype chat. And so I don't know how many we've got here today, but if we've got anybody new, or if someone's going through a ticket or something like that, if they've got some initial questions that they have before we do some role playing, then I'm all ears. That's what we're here for.
Kevin, you're up.
What are you asking for? Yeah, well, I mean, here we are. This is what we do after the shows. I see we have a couple people available. Val, do you have anything to ask?
Yeah, I do actually. I'm doing a motion. Mark, I already submitted a motion to disqualify Judge Hardy. I just made it kind of generic for the jurisdiction, and I'm doing another one that's a little bit more specific. And if you got a couple of minutes, I can probably read it out and get it all out.
Well, this
now comes Val,
and this is Bow in Fort Worth.
Yes.
Yeah, it was good to talk with you again. Well, before you get into it, did you put in there that her bias against you is so strong that a fair trial is not possible, and you know this because she put you in jail and forced a psych evaluation on you for asking a question?
That's what this one I just wrote is kind of like. It talked about all that.
Okay, but the one you already filed didn't have that?
No, it was just kind of generic, just based lacked on acting without any grounds, no jurisdiction to rule over me. Just kind of a generic one.
All right, let's do a little better on these motions, guys. I field an awful lot of questions during the day because I can't always do Skype chats like this in a voice. And so you can always email me or Skype me and ask these questions. And so with these, you want to know, it should be in the template. You have to show that the judge's bias is so bad that a fair trial is not possible, which is why maybe I'll have to update that. So one of the things that we're putting in there is that the judge is taking the prosecutor's claim as absolutely irrefutable and you can't challenge it. And they're not going to allow you to do the same. And so they're not holding the prosecution to their burden of proof, and that's because of bias. And that bias comes in, it's not from a judicial decision. It's something he takes with him to the bench every day. It's political. Because we have to show that it's a bias that's not from a judicial decision, which is easy to do. But you may have the opportunity to be able to change the judge for no reason at all, which most places have. So hopefully that's going to be sufficient that you can get her out of there.
Gotcha. Yeah, I just didn't know. My real question was, should I have multiple options to recuse them? Or motions, I mean. File as many as I can file on different points, or stay kind of lean on the paperwork.
Put all the points in the one motion. Now you can, but you can't do that now. But for anyone listening or watching, put them all in the same one. But since you have not the opportunity to do that, now you put all the new ones, put all the ones you should have put in there, put them in the second one. And it should be, the bias is so great, a fair trial is not possible. And so we have to have the facts to back that up. Now, obviously, asking questions and being, and having your sanity challenge, questioned, yeah, that strikes to me that, yeah, if you can ask a question and she forces a psych eval, I don't think she has any intention of being fair with you. That proved right there she can't be fair with you, because no person in their right mind would have done that.
Yeah, that's how I did. In conclusion, that's what I wrote in conclusion, Judge Hardy has already let the prosecutor engage in prosecutorial misconduct and falsely question my sanity because I asked a question. Judge Hardy has no grounds whatsoever to do what she did. For reckless action, she should recuse herself and should be ordered to have a psyche eval force on her. Is that too much?
I think that's the last part. I agree with you, obviously, but I think that might be a little much for a motion to disqualify the judge.
Okay, cool. I'll take that out. Yeah.
Yeah, just the first part. Yeah, great. And that's so that's what you have for the second motion to dismiss. So if you have her own statements, which I know I've seen some of you've written some of them down, so you can just copy and paste some of that in. Because you sent reports, or someone you knew sent report. Gunner, I think, sent reports to us on Skype. So you have a pretty good idea what the dialogue was. So you want to include her own statements the best that you can in there. And it's a matter of public record that she ordered a psych evaluation, and we know it's because you asked the question. To get back, yeah, definitely include her statements, regarding what she did, so that you can use that against her in that motion to dismiss. And like I mentioned on the show, definitely getting a complaint to the Judicial Conduct Commission and the county commissioners should be in order also. So a lot of what you're putting in the motion to change the judge can be used as a complaint against her with those two departments, with those two agencies.
Oh, yeah, right. Yeah, I am working on some of that. Okay. Yeah, sorry to hold that up. I know it's supposed to be a role play thing, so.
No, that's fine. Hey, wait, that's a good question. I'm glad you came, Do we have anybody who's new that has any questions?
Someone is posting a question in the text chat here.
Okay.
Do we stick to the motions at the beginning, or do we want to try and get right into the softball, the easy questions for the judge?
Well, it depends on how they're going to run it. Now, if you've done it right and you file your motion to dismiss and discovery request before you go in, then obviously we want to have a resolution of the motion to dismiss. So for those who are new to this, the motion to dismiss has to be ruled on, at least technically, they have to rule on the motion to dismiss prior to taking a plea or making any other determinations. That kind of stops things, and they have to decide that. And demur if you're in Kentucky or in California. You don't want to make the mistake, though. And who asked the question?
Just having a look. Not sure.
Okay, it's not.
That was me, Stal from Canada.
Oh, so okay. Hey. It's good to hear from you again. Hey.
What's up, homie?
How you doing? So,
go ahead.
We want to. Yes, you want the motion or the application or the demur ruled on first before a plea is done. Don't ever say that you're refusing to plea. You just want to let them know, sir, there's a motion to dismiss pending. Isn't that necessary to be disposed of before we take a plea?
Well, sir, we have looked at your motions. I find them frivolous, freeman stuff, internet stuff. I deny them. Next. What do you say?
Well, objection, sir. One thing at a time. What in the motion leads you to believe it's freeman sovereign citizen stuff?
Well, sir, if you would like to take a law course for 7 years, I'm sure you can figure it out. But until then, if you require a lawyer, I'm not here to give you legal advice. I deny him.
I'm
the
going to
usual
object.
Kind of stuff like that.
I'm sorry to interrupt. We never interrupt the judge. But Judge, I'm going to have to go ahead and object and ask you why you're deliberately, or you seem to be deliberately misrepresenting the record. I'm not asking for advice. I just want you to point out what in my motion, cite what from my motion leads you to believe it's sovereign citizen stuff.
Well, sir, you obviously feel that we don't have any jurisdiction to hear this matter. That's a frivolous argument, sir.
I would object to that. I don't understand where you get it, because if I filed a complaint against you, wouldn't you file a complaint for lack of jurisdiction, claiming sovereign immunity? So it's not actually frivolous, is it, sir? It's a legitimate defense to challenge jurisdiction, is it not?
Sir, I'm going to have to give you Section 28 for my psych evaluation, because you're sounding a little bit annoyed there, sir. We have jurisdiction to hear this matter.
I'm going to just object, and I'm not going to make any more comments. Just give me your court date, and I'll leave peacefully.
Yes, sir. You can deal with the appeals there. Sorry, Mark.
Well, it wouldn't be an appeal at that point. But and I think the point is made is once they do something like that, which is kind of extreme, you're done. This is something that's going to have to be done on paper. If they're not going to hear you at all, you're going to have to file a motion to change the judge. And now he's actually giving you the grounds to do that, because there are typically 6 parts or arguments that are raised in the application or the motion to dismiss. One of those 6 he should be able to cite, and he's not able to do that. And to then threaten a psychological exam because you're asking for what specific argument you raised that is actually frivolous, not grounds for a psychological exam. So if it goes that way, make your objection and just say, I'm done, just give me my court date, and walk out, because you're dealing with someone who you're not going to change their mind. So at a certain point, you've got to do that so that you can avoid going through what Bao went through. None of us want to go through anything like that. So, but before we do the role play, let's get back to, and I'm glad you brought that up. Okay, but the question was regarding, do we want to softball questions or get into the motion first? So let's go back and cover that, and if we have any questions, we'll get to those. So I want to always point out that when we talk about getting the motion decided or heard, never, ever, ever say you're standing on your motion and you have nothing to add. Don't ever do that. Now, can you guys tell me why I don't think that's a good idea, to stand on the motion and not say anything?
Yeah, but isn't the motion what you wrote out and you don't want to change it? Wouldn't that be possible?
Well, the judge typically is going to ask you, do you have anything else to add? And then he's going to give an opportunity to the prosecution to respond. And a lot of times people will say, I'm standing on my motion, I have nothing else to add. I think that's a mistake. I don't like to do that.
Can you ask, has the prosecution overruled your, not overruled your motion, but have they come back with anything?
That's what you want to do. That's why, because you have the opportunity to put the prosecutor on the spot. And I know it's tough to get them to speak. I get that. They may not say a damn thing. I get it. You still take the opportunity to put the question in front of, to put the question to them, just like you said. The only thing, when they say, do you have anything to add, you say, I want to know yes or no if the prosecution has the evidence to overcome the motion. Do they have evidence and a qualified witness to prove that just because I'm in Canada, your laws apply in this jurisdiction? That's all I want to know.
What if they said, well, sir, are you not a resident? And we have evidence that you're a resident living at, 1010 Main Street.
Is this still Jan?
Yeah, yes, sir.
Okay.
Yeah.
Sir, now don't do that.
I mean, Mark. Sorry.
Well, now who is saying this? Is it the judge or the prosecutor?
Usually, well, the prosecution should be saying that, and usually that's what they come up with, oh, you voted, and therefore you're representative, or yeah, you're a resident, or the charter applies, or the Constitution applies, or the community contract charter, it's et cetera, et cetera. They come up with so many things. We want to be able to deflect that.
Right. Now, have they actually done, does anybody in Canada, has anybody ever had a judge or prosecutor say that in open court?
Not yet, but many, many, many people believe that's what it is. But they're saying, well, they're not really going to tell you, because, if they tell you, the cat's out of the bag.
Well, I'll give you this. The cat's out of the... No, we're not Freeman here, guys. What they will say is a driver's license. If they say anything, they'll say a driver's license. And I use the driver's license, so to me it doesn't matter what the context is, because the underlying issue is exactly the same, right? Isn't whether you're a resident, doesn't that hinge on the prosecutor's claim and the judge, the police officer's claim? That just, look, you're physically here, our laws apply. How many times have we said territorial jurisdiction? It's in the name, right?
Right,
so,
right.
I've had tax agents pull that crap, and so I'll address it as, relate to everybody what I've gone through, and they call a shame, with these actual calls, markstevens.net, where they'll say, but so-and-so's a resident, right? And they say, well, wait a minute. Isn't whether, and so again, you're asking a leading question, isn't whether I'm a resident or not dependent upon whether your laws apply because I'm physically in Canada? Well, okay, but Okay, so let's please just stick. So that's why I'll say to him, can we just stick to the main issue here? You believe that just because I'm here, your laws apply. I understand that. Do you have any evidence to support it? If they say the resident thing, again, didn't we already establish that whether I'm a resident hinges on whether your laws apply because I'm physically in Canada? And that's how I've always addressed it. Now, if they do bring it up in court, that, you know, obviously I would do the same thing. Now, the question is, how is the judge or prosecutor going to respond to that? They may just say, sir, you're physically here. This is most likely. You're physically here. We have jurisdiction. How do you respond to that? I always respond to that. Well, objection. I understand that that is the claim being made. Is there any proof that that's true? Is there a witness with personal knowledge to that? Now, worst case scenario is what we already went through. They try, threaten you with a psych evaluation. But honestly, thank goodness that is like a one in a 900 times that we ever have that happen, right?
One of our new guys here, Terry, is asking, I asked the question, hoping Mark had an answer to start roleplay. I am an alleged Canadian bound by birth certificate or social insurance number that the laws and codes apply to us? Question.
And who asked this? This was someone also in Canada?
Yeah, new guy from Canada here.
Oh, well, welcome.
Yeah, he just dropped off the call.
He just What is going on with my audio today, people?
It'll be on the podcast, right?
Yeah, all right. Well, so, okay. This, I think, is no different than the driver's license. It's compulsory. And so, again, so you're asking a clarifying question, which is, of course, a leading question. Your position is that because I have a driver's license, your codes apply to me, and you have jurisdiction over me. And then you wait for a response. Well, yes, of course, that's exactly what we're saying. And so, well, do you have any, and then again, it's the same thing. Do you have any proof, any witness with personal knowledge that that's true? Now, again, we're getting some background noise. I got to mute you up. Now, you may not get anywhere with that. And this is why I say so many times, you have your status conferences or your I used to have it written right there, and I rate what the pretrial conference is called in Canada, in England.
We call them case management here.
Case management, damn it, that's right, case management. And that's where, at the case management, which is where we can really be effective, because this is where we are meeting with the prosecutor. And how many times have we had reported that the prosecutor stood mute at a case management hearing? Does anybody recall that ever happening?
Just about every time.
Really? That's not what I've had reported. You see, the case management is the prosecutor is usually there and to give you the exculpatory evidence and the evidence he's using against you, and to discuss a deal. Now, they may shut communication down, but you at least have an initial opportunity to question him. And when we've done it in England, look what happened with Helen in England. She did fantastic. That was the whole, that was a big reason why it was tossed out, because she was able to confront the prosecutor face to face, and they were supposed to talk there. So all right, so if you guys are saying it has happened where they stood mute completely like they do in court, I'm not aware of that. I'm sure it happens, but I haven't had it reported on the show.
See, it's funny because a case management hearing tends to be, they say that nothing that happens in a case management hearing can be used in any future proceedings. So it's not recorded, it's not official, so to speak, and they want you to bring any kind of charter challenges to them. But why would we be challenging anything? Isn't it up to the prosecutor, right?
Well, no, you're challenging whether they have sufficient evidence to go forward to trial, right?
Yep, but anything that's been said doesn't get recorded, so you can't use it in any, like, no transcripts or anything of that entire hearing can be used. So
okay, but can the prosecutor, even if you don't have a recording, You can still quote him, or see things that you say typically can't be used. But the prosecution, even if you can't use what they say, they still have to produce the exculpatory evidence, and they still have to produce the evidence to support their claim. So whether you have a recording of it or not does not get them out of their hole. They still have a burden of proof that they have to meet. So, but the point of the case management, even if we can't record it, is to get leverage. Now, it sucks that we have to be in a position at times that the most chance we have of getting it tossed out is the cross-examination. And that it's sometimes our only chance of getting it thrown out. And it's probably not going to get tossed out unless we have to appeal it. But the case management is where we're putting the prosecutor to task and challenging him directly on these things, letting him know we're willing to plead guilty if he has this evidence. Or like when the caller said, I guess, Ron in Vegas, that he's able to do the damage control and have him lower the fine down to a point where he can live with it. So I'm running low on time here. I want to get to and finish what we were talking about as far as the motion to dismiss, because if they want to just deny it outright, this is our opportunity, and chances are they may do that. So what you've heard me say so many times is, look, the motion to dismiss is based on a lack of evidence. So this is our opportunity to object and ask for the grounds. Well, objection, are you satisfied then that the prosecution has met their prima facie burden? Right? Is there anyone not familiar with that particular objection?
Kind of start with, has the prosecution submitted any factual evidence to overcome the motion?
Well, that if the motion, you can start that way, yes. But you can start when they say, "Do you have anything to add?" You're like a broken record. Yes, yes or no. Has the prosecution submitted evidence, facts, proving their claim that just because I'm physically in let's say Canada, that the laws apply and that there's jurisdiction over me. But we're going to say the same damn thing, basically, if the judge just outright denies the motion, like you mentioned earlier, that I'm denying this.
What if they say, sir, we have 200 years of stare decisis and res judicata. If you like any evidence of the jurisdiction, why don't you go up to the library on the 3rd floor? It's all there.
Well, objection, sir. Doesn't the prosecution have the burden of providing evidence in the court? Yes or no? Is it the prosecutor's burden, yes or no?
Well, sir, if we had to provide it for everyone here and behind you, it would take thousands of years to provide you all that, all the people, all that evidence.
Come on, that's only happened one time in the 20-year history of this, right?
I use that one all the time against the newbies.
Well, the thing is, it's not a fair one to use. Because you could come down. So, look, let's just say they say something so unbelievably stupid. And I want to say, for the record, Maria Del Terrio actually said that almost word for word in New Hampshire. She general counsel for them, because she admitted to me on the phone there was no evidence proving the laws applied and that there was jurisdiction. And she did say at a hearing that Bill was at and was not able to record for obvious reasons, right? If they do say something like that, then I think the comeback, the objection is easy. Well, objection. So you are admitting on the record, basically, sir, that the prosecution cannot prove jurisdiction, right?
Well, the prosecution can prove it. They will prove it, but that's a trial issue. The usual.
So we're covering a lot of familiar ground.
Whenever I went to that pre-trial conference, they said he doesn't have to present the evidence. He'll present that at trial.
Well, objection. He's allowed to surprise me at trial. He's not required. He doesn't have a prima facie burden now, and he's not supposed to provide me this information in discovery?
Shoulda, coulda, woulda said that.
Is that James?
Yeah, it is. Hi, Mark.
Hey. Paisan. Yeah, hey, I was there. You did pretty damn good. You had that woman from the Erickson unit. The fact, I don't...
say I object. I didn't say that nearly enough times. What I'm talking about is in my arraignment. That's when I initially blew it.
So Beastline and I have pictures of Beastline. Beastline, wow, he actually said to you, he used that traffic court crap, that jurisdiction was a trial issue.
Well, he actually didn't say that. The judge is the one that said that he doesn't have to provide that information or that evidence right now. That'll be a trial. That will be brought out in trial. Wow.
Yeah.
And then, of course, I didn't know enough to jump where I needed to jump. So,
listen. After what you had her testify to, the fact that those 12 idiots still convicted you is. They didn't even.
I think I bored the spit out of them when I couldn't articulate what I was saying without reading it.
Yeah, that didn't help much. But all right, well, so all right, I'm almost at time for this. So let me get back to all right. So if they do say something like that, I think I just covered that. So if they say they don't have to prove that, well, objection. They don't have a prima facie burden. They don't have to present me anything in discovery at all.
Hey, Mark, haven't you also said that when they say we don't have to prove that? Well, I'm not asking you to prove it. I'm asking you if they have it.
Yeah, that's it. Yeah.
They have.
But they're saying they're saying here in particular they do have it. They don't have to give it to you until trial.
Ah.
So if they do say they don't have to. Now the issue is, I say objection, of course. So objection. So the prosecution can make claims against me without evidence. Do I get that same privilege? Can I argue against them without evidence? I don't have to tell anybody here except for people who are new. That question is probably going to upset them a little bit. So you gotta expect that if they're calm up to that point, this is going to get them a little heated. Because they're going to snap at you. You damn well better not make a claim without evidence. And that's the point. That's what we're asking the question. Then why the hell are you allowing the prosecution to? Anybody can say we've got 200 years of stare decisis if you don't have to prove it. I can turn around and say, excuse me, the IRS's claim is patently frivolous. United States Supreme Court, Gitless first commissioner, absolutely frivolous. It's not what the case says, but anyone can say it. The IRS did lose that case, of course. They didn't use the word frivolous, which would have been nice. But that's the thing about quoting these things. We bring it right back to the prosecution's burden of proof. Look, do they have a burden of proof or not? Do they have to prove this? So I can field one more question.
I'll step in because I was on Saturday night. I don't know if you were on for very long. I was on for all night with Kevin.
No.
But I'm always going to go back to my issue of the property tax, because everything we talk about in here has to do with standing in court and facing a prosecutor and ideally a judge, which is also going to fall into play with the property tax. But it's a whole different set of steps that are taken before you get to that point, and by then you're pretty much in deep trouble. They've already served papers on you. They've got the lawyers involved and everything. So I'm so interested. I realize that jurisdiction still stands, but at what point do I enact that? Do I contact the tax assessor's office and say I want proof that, because you remember I called them and I recorded that stuff and did that circular logic thing. So what am I missing?
Well, you have to get to the tax assessor for the county, and you have to get the assessor. They're working together.
Okay.
And so you need to be able to have and I have that call of shames that for the ones in Maricopa County. Man, the one of them got really pissed off at me. But it's going back a few years in the call of shames. So you need admissions from them. The dialogue, their statements or their testimony, if you will, that they can't prove it. They can't present any evidence. That the best that they can do is say the code applies because it says so. It doesn't actually say that, but that's their claim.
Actually, I mean that's what happened. I mean, because this goes back to last year. You know, when they want their taxes, that's when I go, all right. And I just haven't been able, you know, and I'll probably end up paying them this year just to get them off my back because I just don't feel like I'm prepared. Because after that phone call, and I got that girl on the phone, and she said, well, it's the code. I said, yeah, but what makes that? What do you have to support that code applies to me? Well, because you live here. Well, you know, and we got into this circular thing. And, you know, I asked to speak to the supervisor. I actually asked to speak to the tax assessor himself,
Okay.
a guy named Ron Wright. Well, he's not available. I can put you in touch with the secretary. And of course, she started to run around and said, well, I'll get back to you. And of course, they never called me back.
Sure.
So, you know, it's you know, I know that's where the ball starts rolling. You know, but I know there's a lot of technicals to it, too. It's the fact that nobody's ever appraised my house. How do they know what it's worth? They use comps. And not that should even matter, because they still haven't established an agreement between us, you know, which would establish jurisdiction.
Well, sure. But to be brief, because I'm out of time.
Gotcha.
My card also ran out. I was trying to get this done before the card ran. My SD card on the video ran out. But anyway, I think for your situation, what you can do is make sure when you pay it, you do so under protest so that you can then get an administrative hearing to try to get that money back. And that's your opportunity to get these people into the hearing so that you can question them not only on previous things that they said, but the assessment right now.
Okay.
Under protest.
Right. To do it under protest, is that going to be a formal thing where I go down to the office and fill out paperwork, or do I'm not just going to write under protest on the check?
Yeah, put that in the note.
In what note?
Paid under protest.
Okay. Okay. And so then they're just going to throw that in their account, and that's the end of it, right?
Well, you want to follow it up with a formal request for a hearing that you paid it on the protest. You could take a picture of the check.
Okay.
So in writing, one page. You're doing it on the protest. You want an informal or formal hearing to challenge the assessment so that you can get it back, and then you put in your grounds why. And I've spoken to Ron White's office. They had no evidence whatsoever, only circular logic to support their claim. There was no evidence of jurisdiction. It never should have been done, and based on that, you want it back.
Okay. All right. So I'm going to file with their office, right, or down at the courthouse, obviously.
No, not at the courthouse. It's going to be administrative, so you file it with the tax assessor's office.
Okay. Well, you know, the reason I'm having so much trouble with this is because I can't find any case. I can't find anybody who's done this and been successful at it.
We had one that was successful on the East Coast, so but it is very difficult. There's no doubt. But if you pay it and bring the action on the protest and appeal on the protest, at least we can get somewhere with it.
Mm-hmm.
So get with me off outside the chat, and I'll help you work on that.
Okay, that sounds like a plan. I'll send you an email and we'll do it that way.
Yeah.
Like I said, you can go back and look at your the old archives, because I sent you those recordings and stuff, but it didn't have an end result, so I can understand why there's no reason to pursue it until we've got a plan laid out and it had a result, whether it be good or bad.
Yeah, so
I'd like in on that action too.
Yeah, well, let me know. Well, hey guys, I do appreciate this. This has been a bonus segment for the No State Project, the Roleplay chat on Skype, where we're helping people get the tools necessary by using the Socratic method and logic, leaving the burden of proof on the prosecutor every single step of the way to get at least a favorable resolution, whether it's a reduction or a complete dismissal. And we have plenty of success stories on the No State Project at markstevens.net on the success stories, and we hope to see, if you are one of the new guys, we hope to see your success story there soon. And so until next time, salute.